it is a big place to be, a big responsibility to be an attorney who is making that decision.
A lot of people don't realise that your next of kin doesn't have the authority or the power that we think.
Illness can happen at any time.
We give them the options, we give them the nuts and bolts, because like you said, they're not easy documents to sort of cobble together yourself. You have to make sure there's the right wording.
Some people want this and some people don't, and that is actually the beauty of it. It's your choice.
The assisted dying bill, it's going to take some time before anything is really sort of put in place, if at all.
Hello and welcome to this edition of TV Lawyer Podcast. Today we're going to be discussing the assisted dying bill. Most of us will recall that the end of 2024 took a lot of headline space in terms of this bill that was voted upon in Parliament. Things have been quiet since because the next stage will be one of consultation where the fine detail and safeguards are worked through. So what can you currently do pending the fact that the assisted dying bill is not yet law? In order to discuss this, I'm joined by my colleague, Sade Assibey, who is an associate solicitor at Giles Wilson. Sade specialises in health and welfare issues for the incapacitated or those of us who wish to be prepared for any incapacity that we may experience.
Hi, Melinda.
Thanks so much for coming and discussing this delicate but such important subject with me.
Well, it's lovely to be here. And, my background, I've, had an extensive number of years in sort of assisting vulnerable people, their families, and also health and social care professionals in navigating sort of the world of looking after vulnerable people that don't have capacity. And so it's a pleasure to be able to discuss it. And as you said, the assisted dying bill, it's going to take some time before anything is really sort of put in place, if at all. And so I think it's important for people to know that there are things that they can do now in the meantime, to sort of, tackle or sort of action the sorts of steps that they would want to take. If they were.
And I think that's actually hitting the nail on the head, is that we don't think of ourselves as vulnerable.
No.
We look at people who are vulnerable and feel, oh, goodness, and we can see how upsetting and difficult it is for their loved ones to care for them, do the best for them. But this is all about what we can do to ensure that if we are ever very unwell, have lost mental capacity and become vulnerable, what can we do now?
Yeah, and it's about choice. It's about choice. It's about having those choices that we can make in the future. So health and welfare spans lots of things, day-to-day decisions about, for example, how I'm looked after if I can't look after myself, personal care, where I live, medical decisions. And there we have two things at the moment that we can sort of discuss. One is called a lasting power of attorney for health and welfare. Now, this is a legal document that someone can enter into now whilst they have capacity. And when we say capacity, it means that they're able to make their own decisions about specific health treatments or specific, personal care or specific welfare decisions.
So just to be clear on that, if, for example, I have an elderly parent who is becoming more forgetful, perhaps has had an early diagnosis of a form of dementia, perhaps has had a minor stroke and we're fearful that they could become worse, we could be suggesting to them that although they're not quite as on it, if you like, as they were, they've still got enough understanding to appoint one or more people to be their attorneys for health and welfare.
Exactly. It's important. I mean, these people it's important to choose the people that you want to make your attorneys because they are the people that are going to be making those decisions for you when you can't make
Yes.
those decisions. And so it's important, I think, to think about whether you want a family member. You can also opt for a professional, a solicitor or somebody else to be your attorney, and have those sorts of conversations with your loved ones, with your family, with a professional about your wishes, the kind of things that you want to be put in place in relation to your health and welfare when you get to that particular moment in time when you can't make those decisions or speak for yourself, or you're just incapacitated in a different way. It might be that, you, for example, you find it difficult to understand all the jargon and the bits and pieces and the options that are out there. So it's a legal tool, legally binding, that professionals have to, adhere to. They have to have consultation with your attorneys.
And it's important, isn't it, that somebody giving this power isn't fearful that that attorney will take over their life, because they cannot step in on a decision that you're able to speak up for on yourself.
And also, I think people tend to think that, right, it's about all my health and welfare, every decision. But decisions are made specifically. There's what we call sort of specific issues, specific decisions. So, for example, it could be, I don't know, where do I want to live? Do I want to live at home and be cared for, perhaps, if I've reached that stage of life where I need carers? Or do I want to live at home, or do I want to live in a care home? As opposed to maybe another decision about what sort of medical treatment do I want if I'm in a situation where I have a particular illness. So,
and actually that last one I think is a really interesting one, because if you are suddenly taken ill, not with a long-term consequence, but just rushed into hospital unwell, the medical team would turn to who is your official next of kin. And if they don't know, that would be your spouse, or that would whatever. And so, for an example, if somebody is in a second marriage but has children from a previous marriage, adult children, they may elect that either the spouse and one or two of the children have to decide together, or they may choose their child over their spouse. And so the medical team would be obliged to consult that attorney rather than say, who's this person's husband and wife.
Exactly. And I think a lot of people don't realise that your next of kin doesn't have the authority or the power that we think that they do. And particularly when it comes to making sort of health and welfare decisions, if you are an attorney, if you've appointed somebody, you can appoint a single person, or you can appoint 2 people, or you can appoint 3 people. I mean, it's up to you, but it's important to remember that they are going to be making decisions on your behalf. So they should be amicable, they should sort of see eye to eye, they should agree. But also, you can appoint your attorneys to act jointly together, or they can act joint and severally, which means, for example, if, you've appointed your son and your daughter's on a cruise somewhere, and your son is that person that's in hospital with you, he can make decisions without necessarily consulting, your daughter who's on a cruise.
Yes, and I think it's also really important that parents, if they're appointing their children or considering making a power of attorney, that it can be difficult in a family. You have to be diplomatic and you don't want to cause difficulties. However, this is such a major legal tool that causing a slight upset to somebody because you do not choose them as an attorney, it's important to have that difficult, let's say, challenging conversation amongst the family and say, well, I'm going to be honest, I haven't appointed you as an attorney because I feel that potentially that could be quite a difficult role for you because you're emotional, you'd always, whereas actually I don't want to be resuscitated or I don't want invasive treatment.
I mean, I've got 3 daughters and I often sort of consider to myself, who would I appoint when I get round to making it, which I will do. But they're all they're all very different one's very sort of level-headed, one's very emotional, as you said, and then the other one sort of balances them out. So I think it's important for people to remember that the decisions that will be made are decisions that are in the vulnerable person's best interest. So it's not what I would want for that person, not necessarily what the professionals involved would want. It's about being confident enough to say, well, I know my mum always wanted X, Y, and Z, or she was very much against this, or her wish was always to remain at home for as long as she can. So it's choosing your attorneys is important, that to remember that they will be speaking on your behalf, and they should be confident enough and also just aware of your wishes and make decisions, as the law says, in your best interests.
Yes.
Yeah.
Couple of points before we slightly move on. One is that illness can happen at any time.
Absolutely.
Unfortunately. And so you do not have to wait until you are of a certain age potentially to do this.
Yeah.
But the other thing is, the lasting power of attorney, as we've discussed, is extremely useful for incidents of ill health or for big decisions such as where somebody's going to live for length of time, what level of care they're going to have. Yeah. But there is a part of the lasting power of attorney that does deal with actual end of life, isn't there? And there's also the possibility of another document called an advance directive. And currently they're the two parts that are most aligned to the assisted dying bill. Just to be absolutely clear, the assisted dying aspect is actually having the right to support somebody in ending their life. Yeah. The law currently does not permit that at all, but instead allows life-sustaining treatment to be withdrawn by the medical team, who will not withdraw it unless they know that's what you want. Yeah. And there are currently two ways, aren't there, to let them know that's what you would want.
So, within your health and welfare document, you can express your preferences, your wishes about what would happen if you get to the point where you're at the end of your life and life-sustaining treatment is offered or and it's not something that you would want to, you can detail that in your lasting power of attorney, have those conversations with your attorneys and they will know how to sort of speak to the medical professionals at the specific time. And then separate to your lasting power of attorney, there is a document, another, again, legally binding document called an advance directive, which specifically tackles this sort of end-of-life scenario, life-sustaining treatment, whether you think to yourself, well, actually, if I get to this stage in my life, if I get to this stage in hospital, I've had a good thought about how I want it to go, and actually I wouldn't want life-sustaining treatment to be applied to me. Yeah. It's a legal document. You have to include specific wording on it, and it has to be signed and witnessed. But those are the two documents at the moment, whilst I suppose we're waiting for the assisted dying bill to be decided upon. Those are those two documents available for
very
people.
Tricky. Doing both, do not do it at home.
No.
Because one can cancel out the other if they're not done correctly.
Exactly.
And if the correct wording is not used. Yeah. But we're talking about us sitting here today and saying, some people want this and some people don't. And that is actually the beauty of it. It's your choice. Yeah. If I reach this level of support required to keep me alive, it could be I'm being peg-fed. It could be I'm being resuscitated regularly. Yeah. All manner of medical states that are recited in the document actually. Then actually I would like you to stop applying those and withdraw them, please, even though I know I'll die, is basically what you have to say.
It's that, crucial. But I think it doesn't have to be set in stone. If you think to yourself, right, this is what I want now, this is how I think I want, those documents, you can make those now and you can put your wishes and, your feelings and your instructions down. But if later on, whilst you still had capacity,
Yes,
you
of course.
thought to yourself, you thought to yourself, you thought to yourself, oh, actually,
I've changed my mind.
Yeah. They can be changed. But as you say, I mean, we do that day in, day out in our office. We advise our clients on, we give them the options, we give them the nuts and bolts, because like you said, they're not easy documents to sort of cobble together yourself. You have to make sure there's the right wording. And you have to make sure that you've considered all the facts and all the figures and all the options. And, we do that on a day-to-day basis at Giles Wilson. It's something that we're able to sort of, the advice provide to clients.
And the lasting power of attorney section on this, which is separate than the part we were discussing earlier, is the one that says, I do or I do not give my attorneys the power to tell my doctors to withdraw the life-sustaining treatment. So there's a nuance between that and the advanced directive, which is saying, I'm speaking for myself here, and I'm telling you, please, doctors,
this is
to
what
do that.
I want.
I'm not relying upon my attorneys.
Absolutely.
And the reason you might do that is if you just want to take the attorney's judgment out of it. You want to make it 100% clear to the medical people. Yeah. Because it is a big place to be, a big responsibility to be an attorney who is making that decision, particularly if you're making it for a member of your family and you are the only one that the rest of the family will be looking to make it.
And particularly if it's, you mentioned earlier on that there are so many different situations and scenarios. We don't want to be morbid, but it could be an accident, an accident that just happens, and all of a sudden you find yourself in hospital in a situation where you're faced with either receiving or not life-sustaining treatment, or it could be a planned illness and in a very sort of measured way. So it's I think it's a very, very big responsibility on attorneys. So they have to be the right people, but also the advanced directive is something where you will set out your wishes and feelings and what you want in those scenarios.
Yes, and they're challenging conversations, and you and I have both been making these documents for quite some years for people, and there are so many different types of conversations that we have with clients who, because all family dynamics are different, all of us have different fears. We might come along with a fixed idea of what we think. I have to say, mostly we make it more complicated for people because we raise issues that they may not have thought about. But that is, I think, why it's so important to have a good conversation about it.
Yeah, I think one of the common misconceptions, I think, when somebody comes to us for advice about a lasting power of attorney, particularly for health and welfare. I know there are two. There's the financial and the property one as well. But with the health and welfare one, the misconception is that, right, so once I enter into this document, I then have no say about my health and welfare over to the people that I've appointed as attorneys. And that's not the case. The health and welfare one in particular only kicks in when you have been medically assessed to lack capacity to make a particular decision.
Absolutely. Which is a big distinction from the financial and property one, and it's a very well-made distinction. Yeah. And I think the other part of that is you don't have to have the same attorneys. In fact, you often will have different people because people have different ways of helping you. Yeah. You might choose different individuals.
Exactly.
I think we're running out of time, although you and I could talk for ages on this. So thank you so much for coming along and discussing this. And we'll all be watching the news avidly whilst we carry on with the law as it currently is.
Yeah. Thanks, Melinda.